Yes, Mr. Weir.
Please the court, I think I'd reached the next section, which was there's no need for a traumatic event external to the primary victim. I think I'm being invited by my Lord Legate to try to address that head-on before going via the route of the respondent's concession. I hope I've got that right, Lord.
I wasn't particularly inviting you to anything, but I was saying that that's the point that I think you,
yes,
as far as I'm concerned, is the
yes,
one.
What that is an invitation.
Yes.
So this is essentially a repetition of the submission that I've made before lunch, in that the application of the principle to new facts is the correct approach. So one starts from the basis, what are the principles, and I've sought to set those out. You're looking for an event of injury that at the time of the silent breach of duty can properly be said to be within the reasonable contemplation of the defendant doctor in this particular scenario, and having regard to the combination of circumstances. And that test immediately tells you that there is not necessarily going to be a so-called bright line rule. It may be the case, and I've already sought to provide the rationale for why, in accident cases, the accident constitutes the event, because that's what's within the reasonable contemplation of the employer, the architect, and so the Chief Constable of Police in Hillsborough have asked the same question, whether on the day or whether it was due to prior negligence in the manner in which they've decided in advance to control the crowds. It doesn't matter. If you said to them, what do you reasonably contemplate might occur? Crushing in the pens and being witnessed by close family relatives. And that's the rationale that draws you to it being that accident. The rationale that draws you to it is not all because there is an external to the primary victim traumatic event. That's not what draws you there at all. That's just how it works, the application of the principles in the context of, say, an accident. And we immediately otherwise enter this fascinating world of what's meant by traumatic. We're told it's a bright line rule and terribly straightforward to apply by the respondent. Not only is it not a bright line rule because it's got a rider of infliction of damage. It's got an infliction of damage test which is nothing to do with external traumatic experience. But we've not heard much about what's meant by traumatic experience. We know that the claimant's secondary victim's psychiatric illness needs to be induced by shock, but we don't understand from this whether or not there is an additional requirement that this external event be, open inverted commas, traumatic. That's not necessarily the same thing as horrifying, otherwise it would be properly described by my learned friend as an external horrifying event. And it isn't. He's adopting the language of Mr. Justice Auld in Taylor and Somerset and calling it an external traumatic event. Or objectively, presumably, traumatic, I don't know. What qualifies as traumatic? He says road accidents because you get the mud and the oil and the debris. Well, actually, in road accidents, you get all sorts of things. You can have a vehicle, like a van, grinding to a halt, and the person in the back of the van who's unrestrained, sustaining the most severe injury, because I've had two such cases, a tetraplegia in the back of a van, because you get rattled around in the back of the van. The van comes to a halt, just as careless driving by the van driver, say. There's no damage to the van, there are no marks on the road, there are no external marks at all around. Is this either not qualifying, because it's not an external traumatic event, or is it qualifying, in which case what's meant by traumatic in this context at all? Simply have different cases that arise. I'm pretty sure it's again set out by Lord Scarman, but anyway, this court well understands this point. You simply have the law of negligence has a set of principles, and those of us who practice in the field of personal injury know when a new set of papers comes in and we open them, quite how extraordinary are the circumstances in which people come to be injured. They are many, various, and some of them unique, as it would appear. And the purpose of the law of negligence is not to put things in silos and say, sorry, that didn't involve an external traumatic event. The purpose of the law of negligence is to say, what are the principles I'm seeking to apply? Let me now apply them to a new set of facts. And sometimes you will have, if you like, by way of a flow chart, you'll have a breach of duty that flows its way into an accident, that flows its way into the injury to the primary victim, and sometimes you'll have the breach of duty that flows directly into the primary victim. And the sort of cleanest example of that, without even at that stage the sort of physical intervention of the doctor, is a doctor who prescribes the wrong tablet, puts it on the table, and the patient picks it up and eats it. So the patient takes the tablet, the doctor's not even touching the patient at the time. And it's an extraordinary state of affairs if the law of negligence, without compelling reason, says that category of cases I simply shall ignore. Why? As long as the combination of circumstances allows this court to identify an event of injury which in this court's assessment is an event of injury, and the effect on the secondary victim is something that the court determines as a matter of law was or should have reasonably been in the contemplation of the defendant at the time of breach, and applying the ordinary law of negligence, there will be a duty of care owed. That is the appropriate approach. And that's why one doesn't start with, why isn't it that there's an external traumatic event? It's why is it as a matter of record or requirement? It isn't, and I sought to explain why that is the relevant event in those type of cases. Then turning to the concession, based upon the respondent's concession, it's apparent immediately there is no such requirement in clinical negligence for an external traumatic event, because my learned friend Mr. Maskey expressly recognised a claim could be made by a secondary victim who witnesses the effect of the infliction of damage by injecting a patient with too much of a drug, which causes the patient harm. So the injection of a drug involves no event external to the primary victim, and it could be a tablet, as I say, passed on the table which the patient picks up. There's no accident there in any normal use of that language, unless, as I made a submission on Tuesday, you just call them all medical accidents. There's no oil and mud on the patient. See the observations of my Lord Burrows in relation to the discourse in relation to, really, is McLaughlin really about the key facts where oil and mud? I mean, that's not a good way for the law to be applied. That is wholly unprincipled. So there's no oil and mud on the patient, no torn shirt, no debris of a high-speed accident or the like on the consultation room floor. There's just a patient who's being treated. And as I've already made a submission, the doctor could prescribe the wrong medicine and pass it to the patient. It doesn't matter whether it's the wrong medicine, too much of the right medicine, none of it matters. Either way, what you're faced with there is no need for a traumatic event external to the primary victim. And otherwise, in the world of arbitrary outcomes, see Renane. Renane, paragraph 4, and I'll just give you the reference, page 1117. 1117 was the case of the suture left in the colon. That is the negligent infliction of damage. It is also what I've called silent or hidden, because of course it's inside the patient's body and the patient would be oblivious of this fact at the time. The patient would be under anaesthetic and would not know. That's the positive infliction of damage. Well, what if it was peritonitis that was developing, which was not properly diagnosed and treated? So the peritonitis develops because that's a complication risk of all sorts of surgery, non-negligently. Now we've got a gripping arbitrary distinction between act and omission. So Renane can proceed to secondary victim status, but not another patient in the bed next door who develops peritonitis, which is not diagnosed, and then goes on to have the same florid difficulties, if one changes the facts of Renane because the case failed on the facts, as the patient who's had a suture left in the colon. Still less would one want to adopt the so-called rationale for the external traumatic event of infliction of damage. We know it doesn't marry. That was tested very swiftly by the bench and found wanting as a genuine rationale. My Lord Sales sought to explain that one can have a rationale that doesn't completely mirror, and I respectfully can understand that conceptually, but it has to mirror pretty well, or it's not really going to be a rationale. And when you can immediately say accidents can involve omissions as well as acts, it doesn't marry and can't apply. But if we're really in a world where what's key is infliction of damage, this is remarkably an invitation by the NHS to centre the focus of the court's attention at trial on whether a doctor is guilty of inflicting damage on the patient or letting the patient be ill, which is an incredibly unattractive scenario for the doctors to be asked. Investigating, did you inflict damage on this patient? Are you rooting around? Is it a positive act case? Is there something in there that's an infliction by you as opposed to an omission? And that's a toxic area in the context of doctors that remarkable the NHS would be encouraging investigation into. So our submission, the concession is rightly made but incomplete. And the accurate position is straightforward, and it was summarised by Lord Roger in D&E Sparks. And that was page 40 of the copy that you were given, paragraph 107. In paragraph 107, nervous shock forms a particular chapter of the law. A defendant may owe a duty of care not only to the person whom he injures, but also to that person's parents or spouse who suffer nervous shock through seeing or hearing the event or its immediate aftermath. McLaughlin. Medical mishaps can give rise to such a duty. Characteristically pithy.
That's going to be the...
My Lord, it's paragraph 107. I think you'll find it at page 40 electronically. I've got a hard copy. It's internal 413, but that won't help you so much.
Thank you, that's fine. Thank you very much. 107, yes.
And then in 107, as the court will see, Lord Roger, and this was already noted by the court during the course of the hearing, Lord Roger then acknowledges recovery in the two cases of Tredgerton's, North Glamorgan and Walters, both omission cases. And it's notable that Walters did not involve an external traumatic event. And if you can kindly just go back, I know we've done Walters many times, because my learned friend chooses not to reference this passage, I'm going to go back to it if I may, page 667, paragraph 45. Like Lord Justice Gibson in Sion, I see no reason why liability for nervous shock in medical negligence cases involves any new application of principle. And that is him referencing, and I took you to this before, him referring Lord Justice Gibson's key passage at page 663. So that's the you don't need an external traumatic event. And this is a case that won. And I've submitted in the Court of Appeal, and it may or may be deemed to be arid to sweat whether it is the ratio or isn't the ratio. But it's certainly, whether argued or not, it's certainly a key part of the stepping stone that Lord Justice Ward took himself down, because he's chosen to address the issue. Can I apply the control mechanisms in a medical negligence case? He references expressly Lord Justice Peter Gibson saying absolutely you don't need a traumatic event external to the primary victim, and he says I agree. Paragraph 45. And Taylor and Novo, the Court of Appeal case in which Lord Dyson approves part of Taylor and Somerset, in which it is front and centre to Lord Dyson the issue of external traumatic event, because he's approved a passage from Mr. Justice Ord in Taylor and Somerset to that effect. Does he then describe Walters as wrongly decided? No. And can I take you here to page 638? Paragraph 35. In the Walters case, the court had to decide what was the event for the purpose of establishing a right of action as a secondary victim. The court was able, on the facts of that case, to hold the event was a seamless tale with an obvious beginning and an equally obvious end, played out over a period of 36 hours. It was one drawn-out experience. I don't see how this sheds any light on the question that arises in this case, where the injuries and death suffered by Mrs. Taylor was certainly not part of a single event or seamless tale, etc.
Mr. Weir, I'm reminded that I think you had a 15-minute...
I did, my lord. I was hoping to have borrowed the 10 minutes that I'd...
Well, you could borrow, but only if...
No, I'd foregone in my submissions.
Oh, in your
Tuesday, my lord.
Well,
I was hoping I'd bank those. I did notice.
I do recall you talking about banking them, yes. But
your lordship's nevertheless encouraging me
I am encouraged.
to move on,
Yeah.
as opposed to generally.
Yeah.
My lord, yes. If your lordship will allow me. So this is the case that said, they're in conflict. Lord Dyson has got the point. We're told they're in conflict. In our respectful submission, Walters and Taylor are not in conflict, because the analysis of Lord Dyson, the reasons he gives, are the first and second reasons. And I think there was an observation from my Lord Sales to the effect that the approval of Taylor and Somerset is obviously a part of the ratio. The court has my submission that, with the greatest respect, our case it is not part of the ratio. One, because Lord Dyson is pains to tell us what his reasoning is, 1 and 2, and it comes before that. That is observation by him. Were it a part of his ratio, a Court of Appeal judge, let alone Lord Dyson, would surely have then understood that he needed to say Walters was wrongly decided, because see Walters at paragraph 45 as part of the necessary step to get to the conclusion of a successful outcome in Walters, approving Sion. And that is not what Lord Dyson has done. My next heading was, there's no need for the secondary victim to have been a witness to the breach of duty. That's a concession which has been made. I simply ask the court to have that in mind at all stages. I think my Lord Sales had observed at one stage how it could be said a doctor should have in his contemplation a secondary victim present when the doctor carelessly gave the wrong drug. That is not a relevant consideration on the respondent's own case. In relation to the Californian cases, thanks to Ms. Aria, who's sitting behind me, a pupil in my chambers who has been working hard on coming up to something like the speed at which Lord Leggett is operating in the world of Californian law currently, and we would be delighted to produce a note if that assists the court in relation to what we've discovered about Californian law. Our understanding in relation to Californian law is that, first of all, you can recover. They distinguish between the we might call them primary victim and bystanders. The rest of them are all bystanders. That a bystander can recover in a clinical negligence setting, and we have a case in which they did. That they can recover for an omission as well as an act. That because the test otherwise is simply reasonable foreseeability and they're seeking to limit it, they do so by saying the injury has to be observable. Let me get this right. The bystander has to be present at the scene of the injury-producing event. That's their language. Now, if and to the extent the injury-producing event is the breach of duty, and see the submission I've made, the respondent has eschewed breach of duty, and so this court respectfully could gain no advantage from a body of case law which has reattached itself to the breach of duty. So that's, and in any event, it's part of the case law that is outside the United Kingdom. We've referenced Commonwealth cases which are much more in favour at our case, paragraph 101, pages 154 to 155. Nothing turns on whether the defendant has committed an act or omitted to act. This is an issue which has been of concern to the court, and can I make these submissions first? The contrast, this is a preliminary point, but the contrast is not between a road user owing a duty to the world, as I think it was put, and a doctor's duty to the individual patient. A road user does not owe a duty to the world at all. A road user owes a duty to other people who are within the area of foreseeable physical danger. In other words, people reasonably close by. They might not actually be, they might be on the pavement because you might drive onto the pavement. They could even be in a house because you could drive into the house and knock them over. But wherever you're driving, there's if you like, almost like a circle around you of an area of foreseeable physical danger. Those are the people to whom you owe duty. It's actually a limited class at any one given point in time. So we're not comparing duty to the world. That's simply not an accurate description. Secondly, I think it's very important that this court recognises what Lord Hoffman set out in the Gorringe case, which we've sent to the court, paragraph 38, which I think will be electronic pages 12 to 13. It's a very famous passage in Gorringe judgment of Lord Hoffman, in which he explains that the duty on the doctor rests on a solid, orthodox, common law foundation.
So this is Gorringe, page...
It's para 38, and I'm pretty sure it'll be your pages 12 to 13, my lord.
Yes, it is.
And there's a whole paragraph there. It's because he's looking at it as this is a case involving public authorities. What do we do about statutory duties and statutory powers? And the approach is, actually there are some areas, and you see it at H following down, that are just deemed to be what he calls conventional or orthodox. So a doctor's duty to a patient is an entirely orthodox aspect of the common law of negligence. So although it starts with these words, assumption of responsibility at a higher level of generality, it's not helpful to this court to be fixated upon the sort of Hedley, Byrne and Heller style assumption of responsibility analysis. It's just an orthodox duty of care.
Yeah, but I mean, as he says, it's based on acceptance of a professional relationship with the patient.
Oh, absolutely. Now I can deal with that, my lord. So in relation to that, what's important is that the defendant owes a duty to the claimant. That may be a duty to the claimant, and I'm here looking at the primary victim, falling within a given class, like the road user's example. It may be a duty to a patient as an individual based upon an assumption of responsibility of the most specific nature. It does not matter. In both cases, what's key is that the duty is owed. The way in which secondary victims' claims works is as follows. That duty is then, my language, applied across. It's applied across to a further class of individuals, namely those with close ties of love and affection, to the primary victim. That's not to say the doctor has, open inverted commas, assumed responsibility for the secondary victim. The application across to the class of secondary victims is a product of the recognition by the law that the defendant is held also to have had in her contemplation this further class of people when a duty is owed to the primary victim. And that's not dependent, therefore, on the content of the legal basis of that duty to the primary victim. And so all those concerns fall away. You could say the position is sui generis, or a particular feature of secondary victim liability. The claim is not purely derivative. I've given an example in our written case of the Fatal Accidents Act, section 1(5). The Fatal Accidents Act is a purely derivative claim. If the person who then dies has a claim, you have a claim, the class that the statute says are entitled to claim as dependents. That's purely derivative. But this one has what I might describe as linkage between the two separate causes of action. And this is consistent with the sharing of the breach of duty, which Lord Roger describes in D&E Sparks. That's paragraph 106, which is your page 40, I hope. A, 3 lines down, you see how he says, in Alcock, the House dismissed the plaintiff's claims, even though, again, as a practical matter, the content of the duty which they said was owed to them was no different from the content of the duty which the Chief Constable admitted owed to the people killed or injured in the crush. It's a practical matter, because it's sui generis, it's unusual.
But I thought this was the paragraph where he's saying you don't owe a duty of care to the parents, even if they've attended the consultation for the child.
Yes, my lord.
So he's certainly not in this paragraph pushing the idea of duty of care owed to secondary parties wider, which is what you seem to be saying.
Not wider. I've not extended it at all, my lord.
Right,
I'm simply trying to explain the juridical basis for the applying across of a duty of care from primary victim to secondary victim. And it's consistent with what he's saying is as a practical matter, because it's effectively it's a practical justice outcome, because you share the same breach of duty, but you apply across based upon the control mechanisms, not based upon a further assumption of responsibility. The case law on secondary victims does not say you're assuming responsibility or anything of that nature. It says, have you got legal proximity? And this is the mechanism by which you discover whether you have. And that's the juridical basis for the application across. The content of the duty to the primary care is not to the point at that stage. A different way of putting the matter is the secondary victim has a claim for failure by the defendant to treat the primary victim. I've made some submissions in relation to the arbitrariness of distinguishing on an act and omission basis. Can I just address the court in relation to the example given by my Lord Legate of acting in best interests? That's following Bland and Airedale in the House of Lords in 1989. I can see, my Lord, is very... We are well ahead of time, my Lord, if that's...
Yes,
but there are rules.
There are rules.
My Lord, yes.
We may want to ask questions of your colleagues.
My Lord, yes.
And we're likely to need a lengthy period for deliberation after you've all gone home for tea.
Of course, my Lord. They are...
And you've got one more point that you wanted to...
I do. Can I just...
I understand it, which is there are no cogent legal policy reasons to
My Lord, yes.
row back on the extension of Alcock to clinical negligence.
Yes, I mean, that one I can foreshorten because I think the sort of thrust of the case...
We know what you mean by that.
Yes, I think the thrust of the case is out there. Just in relation to this Bland and Airedale point, if I may, the point about Bland is that what the case held was if you act in the best interest of a person lacking capacity, then the courts can countenance an omission to treat in exceptional circumstances where the patient has no further interest in being kept alive. That's what Bland's about. But we're not in exceptional circumstances, and when you're not in the world of exceptional circumstances, there is a duty to treat. And if you're in the world of a duty to treat, it is not relevantly appropriate to describe a person, the primary victim, as dying of natural causes. You can describe it as that because you can say what's on the death certificate, cardiac arrest. Cardiac arrest is a natural outcome. It doesn't have to be a natural outcome. But relevantly, for the purpose of a claim in negligence, the correct and more accurate way to describe it is the patient died of a treatable illness left untreated due to the negligence of the defendant. And the basic point that was made by my Lord Burrows is in all these cases a death is caused by negligence, and after that it is literally a detail. It does not matter if that's act or omission, because the whole point of the assumption of responsibility is you then treat omissions in the context of the orthodox doctor-patient relationship just as you might otherwise treat acts. What I will do instead, my Lord, just on the legal policy, is just seek to address the observation by Lady Rose in relation to NHS resources, if I may, because I think the rest of it would be me simply rehearsing the sort of case that you have.
Okay.
So just that specific issue, my Lord, if I may. As a matter of principle, it cannot be right to take into account the position of the NHS resources because, first, public authorities are generally subject to the same liabilities in tort as private individuals. The reference for that is Robinson, paragraph 32, page 1199. And as Lord Reid set out at paragraph 33, that means that if conduct would be tortious if committed by the private person or body, it's generally equally tortious if committed by a public body. And that's the observation made by my Lord Legate earlier today. So a court cannot introduce a basis for exculpating a public authority when it's to be treated in the same way as a private body in the law of negligence. Secondly, it would be extremely unfair of this court to speculate as to the cost of secondary victim claims when there is no evidence before the court, but added to that critically, the respondent in this case is the NHS, and the respondent collates and retains the full data in relation to all its settlements. They collect it every year because it has a single body, the NHSLA, which pays for all litigation. And they publish details periodically, and the court may have seen reference in newspapers, the cerebral palsy claims cost this much money. It's because they have the data. So if they'd wanted to reduce data as to the cost of secondary victim claims over the last however many years, they were at liberty to do so. They've elected not to do so, and this court must not, respectfully, therefore speculate in relation to that area. Next point, generalised arguments about the negative impact of an imposition of duty on a public authority have fared very poorly over many years in the House of Lords and Supreme Court. And the most recent example is not on point, but we've put in the case of Darnley at paragraphs 21 to 22. It's a slightly different point, but it was about the NHS, and it was about receptionist. And with respect to my Lord Sales in the Court of Appeal, there was concern raised by Lord Sales that imposing a duty would give rise to defensive practice and the like, and the Supreme Court, see the judgment of Lord Lloyd Jones, was not moved by those concerns. Okay. And that's page 11 of the document that we've sent through to the court. My Lord, I won't seek to tidy it up. I will simply say I'm very grateful for you to give me that extra time.
Thank you, Mr. Burt.
Please, my Lord, my ladies, there's very little my learned friend Mr. Weir has said with which I disagree. And indeed, his submissions are, in my respectful submission, entirely supportive of our case, which I reiterate for the avoidance of any doubt. We say that we succeed on a simple application of the control mechanisms with nothing more. It's a given that the event has to be horrific. And my learned friend Mr. Maskery credits me with advancing a test which is simple in its application, subject to one qualification he had earlier on. He does accuse me, however, of taking the brakes off, a point which I will address briefly in a moment. I do echo my learned friend Mr. Weir's submissions that Novo is not inconsistent with the proposition that secondary victim claims apply in clinical negligence cases where there is an event internal to the primary victim. And as well as agreeing with the analysis my learned friend puts on paragraph 35, I also refer the court to the summary of the defendant's arguments that were put forward to the Court of Appeal in that case on page 623H. It was expressly put to Lord Dyson MR that the same principles apply to medical negligence cases. Forgive me, my Lord, 623G to H. It was expressly put by the defendants as part of their case that the same principles apply to medical negligence cases as to any other psychiatric injury claim, whether an accident case or otherwise. Cognizant of that submission, Lord Dyson said what his lordship said in paragraph 35, which was that the Walters case was distinguishable on the basis that it was a single event which did not derive from an earlier event, a situation which is analytically identical to all three appeals in this case. There was no reservation or qualification to that bold assertion on the basis that what happened was internal to the primary victim or anything of that nature. And it is for that reason that I say that Novo does not derogate from our claim. And I revisit slightly my concern yesterday as to whether it was correctly decided. It is not necessary in my submission for this court to make that finding for the success of these appeals.
So you're not saying that it has to be overruled?
Not in the respect of clinical negligence cases. If this court wishes to clarify or expand the scope, that is another matter. But it's not one I advance to this court.
So you would say that in Novo, the Court of Appeal correctly decided that Ms. Taylor had no claim?
I wouldn't go that far, my lord.
Well, which way do you go?
I take it in two stages. Firstly, whatever Novo decided, it is not inconsistent with...
Well, it decided that Ms. Taylor, although she witnessed the death of her mother, could not claim because she had not seen the accident. So I take it that really you have to say that's wrong.
Well, on a discrete application of the three control mechanisms, that is wrong. But a finding that it is wrong is not necessary for the success of this appeal, because whatever Lord Dyson said in relation to the facts of that case, Lord Dyson approved the outcome in Walters, having been...
Well, I'm not sure you can go that far.
No, very well...
I mean, you just say they were able to find, which is sort of code used on these occasions.
Very well, my lord. Well,
and paragraph 35, penultimate sentence, he says, of Walters, the question whether the death being a separate event was a relevant event for the purpose of a claim by a secondary victim did not arise in the Walters case. I mean, he's just, as I read it, saying it's not helpful to what we're having to decide is the issue in our case.
It does not arise in these cases, my lord, because in these cases there was no earlier event.
No, but supposing there were. I mean, take a clinical negligence case.
Yes, my lord.
Where the secondary victim is present when a clearly traumatic event occurs and the primary victim is injured, seriously injured. And in those circumstances, undoubtedly, the secondary victim has a claim.
Yes.
Then, 2 weeks later, the primary victim dies horrifically in the presence of another secondary victim.
Yes, my lord.
Question, can that secondary victim succeed in a claim?
On a pure application of the three simple control mechanisms, in theory, yes. But in reality, it would be highly unlikely.
Why?
Because why on a
why should the secondary victim not succeed on your case?
Well, on a pure application of the principles, it should succeed, and no doubt that is a matter which may be of concern to this court. But what I say in practical terms is that it is unlikely to succeed because it will no longer fill the criterion of being horrific, because the...
well, that's a factual matter, but
yes,
I'm asking you to assume it is horrific and sudden.
On a pure application, it should succeed.
Yes, I mean, whereas in Taylor and Novo, Lord Dyson said it could not succeed.
Yes. Well,
not on the facts it can't succeed,
yes,
but it cannot, as a matter of law, succeed.
If that is the conclusion to which he
Don't be shy about these things. As you rightly say, you've come to the Supreme Court to settle the law in a difficult area, and that involves saying
I recognise
that should be overruled.
I recognise that any judgment involving Lord Dyson MR should be treated with the greatest respect.
Of course.
But on a pure application of the three simple control mechanisms for which we contend, that claim in your lordship's example should succeed.
This goes to the heart of the problem that the appellants face on the appeal, because you either have to go your way and say that there's no need for an accident even in the accident cases. That requirement goes because the injury, witnessing an injury consequent on the accident is sufficient. Or you say, go the other way and say that where there's an accident, subsequent injuries don't count. And then that seems an utterly arbitrary distinction to introduce into the law. That's the way that Mr. Weir goes. So, you know, you're caught in that dilemma.
Well, it's not arbitrary, my Lord, when one considers the problem which the law is designed to compensate for, namely the witnessing of death, injury or imperilment in horrific circumstances. And when it's viewed like that, my Lord, the source of the death, injury or imperilment is of no consequence. And if the law attaches significance to whether it's an accident or otherwise, internal or external or otherwise, then the law falls into division and justice is frustrated, in my respectful submission, because what is intended to be compensated is the perception of the horrific event in the mind of the secondary victim. The source of that horrific event, to put it bluntly, is not relevant.
Can I ask you this? On your formulation of the principles, is there any scope for the aftermath, the immediate aftermath?
There is, because if I can put it like this, the actionable wrong is the perception of the horrific event in the mind of the primary victim, be it the perception of injury, death, or imperilment. It matters not whether the source of that perception is an accident or the immediate aftermath of an accident. And that's why my learned friend, Mr. Maskery's objection that one cannot have the immediate aftermath of imperilment is of no consequence. It's not comparing like with like. The accident or its aftermath is the source of what must be perceived, which is death, injury or imperilment. And the fact that it's conceptually difficult to conceive of an aftermath of an imperilment is neither here nor there, if I can put it like that. What suffices for the purposes of this law is that death, injury or imperilment is perceived and it's horrific from whatever source.
And you're not suggesting, or are you, that if you've got a horrific death, people who come across that horrific death, not immediately, they're not there when it... So let's take the cases you're dealing with. Of course, we've got mothers who are at the scene.
Yes.
Let's say the child dies, but the mother's not actually there.
Yes.
She comes across it.
Yes.
Is that within the scope of what you're talking about?
Well, it's death, and its source is the aftermath of an earlier event, and so it is recoverable. I suppose it's subject to the immediate aftermath exception, which is a limitation in time.
But what are you applying the immediate aftermath to? Sorry. As I understand it, your case is that the relevant event is the horrific death.
Yes.
We know that the event, as explained in McLaughlin and O'Brien, etc., includes not merely seeing or being present at the event, but also the immediate aftermath. Yes. So what I'm really asking at is, Mr. Maskery was very careful to say, I think, you can't have an immediate aftermath on the case that you're putting. And so I'm really asking you, do you agree with that submission?
I can see my Lord's point. Is it the immediate aftermath of the death, or is it the immediate aftermath of the event that caused the death?
But in your case, the relevant event is the death.
Yes, on that analysis, it would be.
Yeah. I mean, do you go that far, actually? I mean, you're not actually saying, are you, that the claimant could not succeed if they were present at at the traumatic at Hillsborough,
Yes.
and believed that their loved one had been killed or badly injured. You don't have to throw out that case in order to make yours, do you?
No, indeed not.
No, and so I suppose the aftermath to that, an aftermath to a traumatic event, yes. You'd say, I mean, it's a slightly odd extension, but it's there.
Yes. The Hillsborough case, what the spectator in the stands is witnessing is imperilment. That's what they perceive, and that is what
they might actually see their loved one crushed to death.
Yes, either would
yes.
meet the requirements for recovery.
But where I think it does. If I can just press you a little more on the Novo point, I think you have to say, don't you, that the element number 4 in Lord Oliver's list of 5. Number 3. Yeah. Presence at the accident is actually OTO, so he was wrong to include it as an element.
Well, I must expand upon my learned friend Mr. Weir's submissions that those are not definitive of control mechanisms. If I could indulge the court to permit me to refer back to Alcock yet again, I refer to the relevant dicta of Lord Oliver.
I think it was page 573.
573, I'm grateful. We should all know.
Sticks in the mind at this
point. We should all remember this by now. Yes. The relevant word to which I attach weight is, forgive me, it's 573. Yeah. The relevant word to which I attach weight is that it is from these elements that the proximity must be deduced, not decreed, not set in stone, but deduced. And a dictum which I don't believe has been referred to the court as yet appears at 578H to 579A. And it will be seen from this dictum that having set himself the task of deducing the control mechanisms from those 5 common elements of previous cases, Lord Oliver does deduce what the control mechanisms are, and he sets them out in traditional form. 578H, in my opinion, the necessary proximity cannot be said to exist where the elements of immediacy, closeness of time and space, and direct visual and oral perception are absent. So his lordship has gone from posing himself the task of how do I deduce proximity elements or proximity control mechanisms from 5 common features of earlier cases into control mechanisms. And he comes up with the answer which the 6 other law lords came up with in the various judgments that I referred the court to.
Well, with respect, I mean, that sentence is difficult to understand without having read the exposition of it that occurs earlier. I mean, I think you'd be struggling if you read that sentence to know what he was referring to.
Well, I don't only refer...
Well, you have to read it in the context of his speech. But either way, can I just ask you this? Is it a necessary part of your case to say that really the third element of page 573 does not have a part to play?
Well, I say it does have a part to play, okay. But not for the reason my lordship may consider. Okay. It has a part to play because it's adding the requirement of immediate aftermath, or the possibility of immediate aftermath from earlier cases. I don't believe...
No, I'm sorry, that really won't do with it, because it has 2 elements.
Yes.
Thirdly, that the plaintiff in each case was either personally present at the scene or was in the more or less immediate vicinity and witnessed the aftermath. They're either or. And I think you're...
And that's the aftermath of an accident anyway.
Yes,
so
yes. He's referring to
either you knock out the accident and it's including its aftermath, or you leave it in.
I submit, and I repeat my submission, that his lordship there is not seeking to set out definitive control mechanisms, right. and his lordship is not saying that from hereafter only those who witness accidents in the traditional sense will recover. And I refer my Lord Legate again to what his lordship said later on page 578, letter E, in which his lordship said, no case prior to the hearing before Hidden J from which these appeals arise has countenanced an award of damages for injuries suffered where there was not at the time of the event a degree of physical propinquity between the plaintiff and the event caused by the defendant's breach of duty. Further down, the necessary element of proximity is furnished at least in part by both physical and temporal propinquity and also by the sudden and direct visual impression on the plaintiff's mind of actually witnessing the event or its immediate aftermath. The reference to accident has gone, and what his lordship is focusing on there is the perception in the mind of the secondary victim, which is what I focus on for the purposes of my submissions.
So in another case, just to be clear, where there is an accident, the secondary victim has not witnessed the accident, they're not present there or the immediate aftermath, but the primary victim is a relative who's injured in the accident and some weeks later suffers death from a consequence of the accident, then they recover.
Those facts, if I understand them, my lord, are analytically identical to novo.
Yes, so the presence of an accident is irrelevant.
Well, I would have to submit that on a pure application of the three control mechanisms, that must be right. But that does not open the floodgates for reasons which I will briefly expand upon.
I'm sorry to press you because I'm still not satisfied I've had an answer to my question about the immediate aftermath. Let's assume we're not in an accident scenario. Yes. Do you say yes or no to whether there's any role for the immediate aftermath?
I say that if it's conceptually impossible to conceive of an immediate aftermath, that is not fatal to the secondary victim claim, so long as what has been perceived is death, injury or imperilment in horrific circumstances. And I say that because the House of Lords was not purporting to be definitive on all circumstances in which people can claim in these sorts of cases.
But I'm giving you the hypothetical switch of, in our cases, the mother's not actually being there when the child dies.
Yes.
But coming across the death very shortly afterwards.
Yes. That, I would submit, is the aftermath of an event which leads to the perception of death and therefore is recoverable.
Right. So I understand you to be saying that there can be a role for immediate aftermath on the role on the approach that you're taking.
Yes, my lord. What it boils down to is I refute my learned friend Mr. Masque's suggestion that the impossibility of there being aftermath of imperilment is fatal to the conception or the argument that one can succeed in a non-accident situation.
Well, you have to take that view of your case, don't you? Isn't your case an aftermath case?
It's arguable that my case is either, because my client did attempt to resuscitate the deceased and did hear in real time the deceased dying breaths. So it's arguable that she was part of the actual death process, if I can put it in those indelicate terms. But if you're against me on that, then it was manifestly a case of immediate aftermath.
She didn't hear it in real time, did she? I thought she only listened to the mobile phone call after she got back.
That's right.
And her daughter dead. Depends what you mean by real time.
Well, yeah, exactly, my lord.
She heard it, as it were, over a period of time that was the same as it had been in real time.
She heard the unfiltered, unvarnished dying breaths.
She heard a recording of it.
Yes, but unfiltered and unvarnished.
Yes, sure.
Just finishing off the point about Alcock, it is the case that their lordships did not purport conclusively to restrict recovery in the situation that was before them. As my learned friend Mr. Weir has pointed out, they only had to consider 3 issues, and they left open the possibility of recovery on those 3 issues. They said, for the purpose of this claim, the relevant claimants don't fall within those 3 issues, but we don't discount the possibility of recovery in later cases. And one particular dictum, and it's the last one to which I'll refer the court from Alcock, is particularly revealing. It's that of Lord Jauncey at 585H. What constitutes the immediate aftermath of an accident must necessarily depend upon the surrounding circumstances.
Sorry, what was the page?
Forgive me, 585H.
Oh, sorry, I got the wrong one. Yes.
What constitutes the immediate aftermath of an accident must necessarily depend on the surrounding circumstances. To essay any comprehensive definition would be a fruitless exercise. So his lordship was expressly declining to definitively define the concept of immediate aftermath. I attach no particular significance to that issue, but I do say it's indicative of the approach, which is we're setting some general control mechanisms, and they will be developed and applied to facts in the future as and when. Similarly, this really is the last quote, 584H of Lord Jauncey's judgment. He's disputing or rejecting the claim based on proximity of relationship, but he's not closing down the possibility that there may be sufficiently proximate relationships in other than the traditional categories. And he says, if the claimant has so established and all other requirements of the claim are satisfied, he or she will succeed, since the shock to him or her will be within the reasonable contemplation of the tortfeasor. If such relationship is not established, the claim will fail. That is a significant statement of intent of the House of Lords in Alcock, because what they were saying was these categories of recoverable claimants are not closed. There's a possibility they will succeed if they prove that they should have been in the reasonable contemplation of the tortfeasor. And that is what we say is exactly the situation in the current appeals.
They're talking about the degree of relation. He's talking about the degree of relationship.
Indeed, my lord, but it's indicative of the approach that they propose to adopt. I say rather dramatically a statement of intent.
You say that in Alcock the House of Lords was setting general control mechanisms.
Yes, my lord.
But at the same time, I rather hear you saying, yes, but they're rather particular to the facts of the case or the type of case. You know, are they general control mechanisms?
They are. The status of the Alcock control mechanisms are that they are tools to be applied flexibly to novel facts.
Or to be ignored if necessary.
Not to be ignored, because with respect, my lord, because all the law lords coalesce around the 3 basic elements: proximity of relationship, proximity in time and space, and direct perception, including Lord Oliver in that dictum to which I've referred, my lord. So what they're saying is, here are the 3 tools, the categories to which the facts to which these tools may be applied, and the categories of people who may be successful following the application of these tools is yet to be determined. In effect, go away and get on with it. What they weren't saying was, as my learned friend suggests, that these are definitive, this is it. We're not going to allow recovery in any other cases. To conclude my submissions, I say that there is very little, if any, difference between my learned friend Mr. Weir's approach and mine now. I say that we succeed on pure application of the three control mechanisms, and it's a given that it must be horrific. And if I don't misunderstand my learned friend, he contends for a flexible approach of the control mechanisms to situations as and when they emerge. And he says, and I believe this was the gist of what he was saying, one has to identify a witnessable event of injury reasonably in contemplation of the doctor at the time of silent breach. Now, what was in contemplation of the GP in our case, whose mother happened to be sitting there as well, but that is not necessary for the success of the claim, was that if I don't treat this young woman properly, then she may die of pneumonia. And when that horrific event emerges or occurs, that is within his reasonable contemplation. It's not necessarily linked to any particular injury, but it's within what he should have reasonably contemplated. My learned friend, Mr. Maskery, gives me the credit of advancing a simpler, easier to apply test, although he says it's possible that a rather grim vista can be opened up of the court having to consider whether one person's horror of witnessing their loved one die is worse than another. I say that's an illusory fear, because in clinical negligence cases, an unexpected avoidable death is by definition horrific. And it would be very unlikely in most cases that the NHS would or the medical defendant would realistically dispute whether a sudden unexpected death was horrific. And if they did, it's a rather paternalistic point to make to the claimant that they ought not to go to court because it may be too distressing for them when the court decides whether the event is sufficiently horrific. It's up to them whether they want to run the claim, and that is one of the factors that all litigants take on in personal injury and fatal accident litigation. It's suggested that I'm taking the brakes off completely. I'm not, because the control mechanisms are still there. There is still the requirement for horror, which is a very real hurdle in clinical negligence cases, in particular taking into account the dictum of Lord Justice Tomlinson in Remain, which was to the effect that if one goes to hospital, one is prepared for horror and a disturbing event, and therefore one can't claim. I believe it was my Lady Rose who yesterday raised the potentially troubling example of a clinical negligence victim, as it were, suffering a horrific stroke on one day and then a horrific further event a few days later. Does that mean that there's potentially unlimited liability because if a loved one witnesses each of those events, they can recover? Well, in principle, there is that possibility, but the reality is that it's highly unlikely ever to occur, because once the first horrific event occurs, then everyone is going to know that that person has got a condition, and they'll be prepared for the second horrific event. And it's highly unlikely that the court would find in that situation, taking into account Lord Justice Tomlinson's dictum in Remain, that second event was horrific. And it's even more unlikely with respect that most lawyers would go to trial on that issue. It is unlikely to happen. My lady Rose made the point that at least in PI cases, when the RSJ falls down, whether it falls down on 10 people or 100, the loss is crystallised at that point. And that is the suggestion being somehow better to contemplate than the potentially unlimited liability in clinical negligence cases. Well, I say that while that principle and that distinction is firm in practice, in reality, potential exposure to the negligent designer of the RSJ in the PI case is going to be much wider than that of the doctor in the clinical negligence case, for the very reason that I've just articulated, that once the first horrific event occurs, it's very unlikely that the court is going to find that any later events, however distressing to witness, fill the criterion of horror, which we accept as a necessary ingredient to these sorts of claims.
Can you just... I didn't quite follow the submission that you made about unexpected avoidable deaths.
Yes.
I thought you was indicating that there wouldn't be... sorry, I beg your pardon. At one stage you were saying, well, there wouldn't be all sorts of claims, but I understood you to be saying that wherever there was an unexpected avoidable death, that will, in most cases, be horrific.
Yes, the control mechanisms, so long as they are satisfied, an unexpected avoidable death is likely to be regarded as horrific, and the court is unlikely to engage in a gruesome inquiry as to whether there was sufficient blood and all the rest of it. But that doesn't open the floodgates.
Most of these, I mean, because you've got a negligence, these are unexpected avoidable deaths.
Yes.
So aren't you then saying that every
No.
negligently caused death by medical negligence is almost inevitably horrific?
No, because very few will have the coincidence of occurring in the community and witnessed by a loved one at the time.
That's not the question as to whether it's horrific.
Well,
That's the question whether you've got a loved one there or not.
It's a matter for the court whether it's horrific or not.
But I thought you were saying it isn't really a matter for the court because they're all horrific.
Well,
I thought the whole point of this submission is to get away from the point
Yes,
that it's invidious to compare the horror of particular death.
yes, that my Lord Sales makes that point.
Right.
And it is invidious to compare different sorts of death, but in reality, that exercise won't be gone through in most cases where there is an unexpected death. If you'll permit me to turn my back from you.
He's not quite over his time. He's not quite over his time. Isn't he? And it's almost all been injury time.
Yes. Yes. I don't know.
I accept my Lord's point that there may be a concern that if every death unexpected was by definition horrific, that would open the floodgates. I don't necessarily concede that every death is horrific by definition, by virtue of the fact that it suddenly occurred, and perhaps that submission goes too far. But what I do say is that horror is the sort of thing that is difficult to define, but is easy to recognise when it's experienced, and the sort of gruesome inquiry that my learned friend Mr. Maskery envisages as to how much blood there is and so on is unlikely in reality to detain the court.
But if your claim goes forward in this case, if you win and this claim goes forward, isn't that exactly what the court will have to decide? It's not generally admitted, as I understand it, otherwise than for the purpose of this appeal, that this death took place in circumstances which were sufficiently horrifying to satisfy that test.
Who knows, my lady, because we haven't got the figures as to what cases are settled and what
I'm talking about this case.
This case, the facts of this case are very likely to be accepted as horrific. Any dispute...
Accepted by whom?
Well, objectively, the facts of my case are horrific, I say, and that's what I would say at court. And whilst we haven't had any formal admissions, my case being a case in point, if the court is confronted with these sorts of facts, the court would have no difficulty in identifying them as horrific. And there wouldn't have to be the sort of inquiry into gruesome detail that my learned friend, Mr. Maskery, fears.
People die unexpectedly all the time.
Yes.
I mean, how does one apply your horrific test? You don't know often at the time someone dies whether there's any medical negligence in the background at all. Is the test in effect just unexpected death? And that opens up, well, let's look to see if there's any medical negligence associated with that death. But the very fact that it's unexpected satisfies the horrific criteria.
For the avoidance of doubt, I retract any suggestion I made that an unexpected death is, by definition, horrific. I say it's one factor to take into account. And if a person who is not expected to die and who is not ill, visibly, suddenly drops dead, that is one factor to take into account in considering whether it is horrific or not. It is not a decisive factor. It is not the sort of thing that will happen often, but it is one factor to take into account with other circumstances around the event.
So if I may say so, that does sound as though you're then retreating into a world where one does have to make invidious choices between different degrees of horror in relation to unexpected.
But not to the level of detail that my learned friend fears.
You'd have to look at what had happened in the preceding days. How ill did the person seem? If they seem too ill, then that won't be that unexpected. But if they didn't seem at all ill, or just a bit, then you'll be on the right side of the line. That's the kind of question you'd have to ask on your approach.
Potentially, my lord, but maybe not. Certain events are so distressing that they are obviously horrific, and that reflects my point earlier that horror is difficult to define, relatively easy to identify. And I submit that this inquiry into detail will not be as commonplace as my learned friend suggests.
I'm conscious that almost the entirety of your allotted time for reply has been taken up with answering our questions. Yeah. So I was just going to see if there's any other aspect of the matter you wanted to develop, as it were, afresh, rather than merely answer our questions.
No, I don't
coming up to your time. Thank you. Thank you very much. Yes, Mr. Pitcher.
My lord, my lady, I can be very brief, but not least because I'm third on again.
Don't bet on it.
Well, I can be brief. Whether I can deal with any observations briefly is another matter. The reason I can be brief is because you have heard from Mr. Weir this morning and this afternoon a very comprehensive, I would suggest, convincing response, a rebuttal to Mr. Maskery's articulation as to the law. As you might expect, I had made copious notes in preparation for my reply, and I've been going through, ticking off, I've crossed out pages of fantastic points.
Yes. We've all been there.
You'll all have to trust me when I say that all of the excellent points you heard from Mr. Weir I'd thought of.
And the ones that weren't so good, you weren't on it.
But in all seriousness, I don't seek to repeat what you've heard. I can't add to it or better it. And it does seem, in my respectful submission, that this case has really come down to a core issue, which is whether or not you adopt, as an extra control mechanism, accident or external event, however that is defined. And if you don't, frankly, if there's any difference between the appellants now, it's difficult to get a cigarette paper between us, because it seems, with Mr. Weir's helpful articulation as to his test, it seems to be, as far as I can tell, the same as ours, which is the application of the control mechanisms. In his case, he says it's a first manifestation, therefore it's satisfied, but he's not putting that forward as a test.
He didn't repeat it in his reply, but I'm not sure he abandoned it by any means.
I think what he made clear, and he made it clear in his oral submissions before, is that he...
I think he made clear, well, he'll stand up if this is wrong, there's only one incident that can found recovery, but it's not necessarily the first manifestation.
Yes.
It's the most significant.
Well, and that may be the area where there is a subtle difference between us, because I do take the point head on that the position that's taken by Purchase and Polmear does in effect, unless one were to take a very narrow view of the ratio of nova, does in effect require us to say that should have been decided differently. Yeah. And I don't back away from that conclusion. My lords, my lady, unless there are any other matters upon which I can assist you, those are my brief submissions and reply.
That's extraordinarily concise.
Yes.
Thank you very much. Well, we are extremely grateful to all counsel, and also those sitting behind and working behind them for the presentation of the written submissions as well, and for your patient and polite response to an endless barrage of questions, but that barrage merely demonstrates what a difficult and important case this is, about which we will of course now take time to consider our judgments. Thank you very much.